Adam, I want to ask you about the contentious nature of it. You said it was contentious right from the get-go, and E. Jean Carroll didn't cry, but there seemed to be a real emotional back and forth between her and Joe Tacopina, Trump's lawyer.
And that's a very good point. From the get-go, yes, it was contentious from the word good morning, and she did not cry. She cried on the first day of direct examination, but for Joe Tacopina, it seems that she didn't want to give him the satisfaction. She was very tightly controlled over everything that she said. As a matter of fact, that passage that you just read, that when she said, "He raped me, whether I screamed or not," that was the loudest that she got. But even then, it wasn't a shout, it wasn't a scream, it was assertive. It was her saying that no matter how many times you ask me the question, it doesn't change what she said happened.
Faith, let's talk about what Tacopina's approach here is. He's trying to unsettle E. Jean Carroll. I guess lawyers do that. E. Jean Carroll is a strong character. She's vulnerable, and she's talked about her vulnerabilities yesterday. She talked about the effect that this interaction with Donald Trump has had on her life. Talk to me about how you think she's interacting with Tacopina.
You know, as a cross-examiner, what you're doing is walking the world's thinnest line between love and hate. And what you're trying to do is needle the witness while not making the jury or the judge hate you. And I think Tacopina did not quite accomplish his goal today. The jurors seemed to be a little bit spaced out, especially some of the younger male jurors. The judge got bored and frustrated with Tacopina, thereby becoming the most influential juror of all, because the judge made a number of comments right in the face of the jury about Tacopina's hostile questioning. I think Carroll responded very well. I mean, she's no shrinking violet. She can't pretend to be a little lamb. She is sort of a combination of vulnerability and aggression, and she showed that today. She played to type, and she responded very well to what everyone knew would be an aggressive examination by Tacopina.
Let's talk about another point that Joe Tacopina, Adam, kept trying to make, and it was this idea of there not being a specific date attached to the alleged incident and the not filing a police report.
Absolutely. Now, he said time and time again that she didn't file a police report. And as a point that was made earlier, that was one of the points that really piqued the judge. Judge Kaplan said that he made that point some 20 to 30 times. The judge joked that it's one of the most notorious facts other than the New York Yankees not winning the World Series in years. He was essentially saying, get on with it. As to the point about the date, E. Jean Carroll has said for a long time it was in the mid-1990s, either 1995 and 1996, and that she's been struggling to piece together the context clues. Now, the point that she made is if I wanted to fabricate something, if I wanted to make up a story, I wish I could give you the date that if she wanted to, and it was a point that she made earlier with a different point about screaming. She said she could have said, I screamed my head off, and then maybe you would have believed me. But you could see throughout her testimony, her using context clues like, for example, the fact that one of her friends, the one who's on the witness list, Lisa Birnbach, had gone to Mar-a-Lago for an article in February 1996. She says that's significant because if Lisa had been told before that Trump had raped her friend, she wouldn't have done that, which is why she now thinks it was in the spring of 1996. And so you can see on the witness stand in real time her trying to put the pieces of the puzzle together.
Faith, talk to me about what that does to her case. The idea that Tacopina keeps hammering on the date, the lack of filing a police report, and the fact that she didn't scream.
It puts a huge amount of pressure on Carroll's lawyers to contextualize this. She's almost an 80-year-old woman. This happened 30 years ago when women did not report crimes to the police. when they try to carry on with their lives. And the opening statements by Carol's lawyer really contextualize that, and they'll have to come back to that time and time again to make the jurors remember this is not a current day situation. And I think that Carol got to that a number of ways today. She tried to make sure that people understood the time frame, what she was thinking about, what her conversations were, and the advice that she got from her other two friends. In a certain way, she really triangulated testimony, because now it doesn't just depend on her, but it depends on the advice her two friends gave as well.
Adam, something that Faith told me about on Monday is that this judge wants to keep order in this case in the courtroom, but is walking a thin line between keeping order and getting into an adversarial relationship with Joe Tacopina. That came up again today, in which the judge sort of told Tacopina, these are my rulings, you need to abide by them.
Yes, and it was a very pointed remark. He said, in this courtroom, the rulings are the rulings, and the rulings are not an open invitation for a debate or an argument. And it's, I should say, I mentioned a little bit earlier about the judge making the remark about him making the point about the police report 20 to 30 times. The jury wasn't present at that moment. They were gone for the day. And so I think the judge, or any federal judge presiding over a case for that matter, is going to be very conscious not to give off some sort of idea that he is favoring one side or the other. And I think that line has been walked very finely throughout.
Right. This seems like a tense exercise for everybody involved, because the judge gives off cues and clues to the jurors. So he wants to be strong, but there's a line judges can cross with jurors where the juror thinks the judge is taking a side in the case.
Well, that's why cross-examine is the most delicate art in the world. And that also includes how the judge reacts. Here, if the judge expresses displeasure a few times, the jurors tend to be very sympathetic and really influenced by the judge, right? He really almost starts to sit in the box with the jurors. But if the judge goes too far, then the jurors have a sense that their principle, their feeling of fairness has been violated, and they start to go in the other direction. I thought Judge Kaplan was smart today as he started to lose patience as the afternoon wore on, that when he felt like he was about to explode, he then let the jurors go for the day around 4:30 and engaged with Tacopina outside the jurors' presence. I thought that was a very wise move.
Adam, while you were watching this all go down, I was watching to see if Donald Trump was going to post anything on social media, because the judge warned Tacopina that posting things that are not supposed to be posted in the course of a trial is a dangerous matter. Donald Trump didn't post anything today.
Absolutely. And I think every reporter in New York City was looking to see whether former President Trump was going to post anything about this case this morning for that very reason. He was warned. And he didn't just post about the case. He didn't just post an attack against E. Jean Carroll. According to Carroll's attorney, he had violated court orders not to raise certain subjects, like litigation financing. That was not to be brought before a jury. He was not supposed to attack supposed political ties by her legal counsel. These were pretrial rulings, and the judge said he was making those statements to his supporters and arguably perhaps trying to make it to the jury, even though they are instructed not to follow the media coverage.